It's not going to take much for me today to lose my. I'm right on the verge. I am at my word limit.
Good morning, Your Honor.
Good morning.
I have one witness in this case.
Good morning. Are you Jonah Ray Johnson?
Yes, Mom.
And this is 25 DCCR 1775. Mr. Johnson is charged with aggravated assault with a deadly weapon. And Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case. Are you calling your client?
Yes, Your Honor.
Mr. Johnson, best you can, raise your right
Oh,
hand.
no, I'm sorry, Your Honor. I'm not. I'm calling my client's mom, Jacqueline Broussard.
Miss Broussard? Mr. Johnson, if you'll just come around just to the side, right there on the corner. Ma'am, if you'll come right over here, please. Good morning. And would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Yes. Thank you. You may proceed.
Thank you, Your Honor. Ms. Broussard, state your name for the record, please.
Jacqueline Broussard.
And you've done this before, haven't you?
Yes, ma'am. Oh, sir, I'm sorry.
And you are Jonah's mom, correct?
Yes.
And the original bond back in September was $150,000. Wasn't that correct?
Yes, sir.
And what went wrong? What was the problem there?
The ankle monitor. We thought it was broken, which we was led. That was, we called Johnny, and Johnny told us to come in, which we had been talking with Johnny for 2 weeks. But like I say, Johnny said come in, and something's going on with the monitor. And we also was the payment behind.
Okay.
But we like. I'm sorry. Go ahead.
That's all right. The bondsman said the defendant has failed to pay for the GPS device. It wasn't charged. He will not respond to surety's attempt to reach him. He cannot be located. Surety feels like his bond is at risk. Now, you disagree with that, right?
Yes, sir.
The bond was never at risk.
No, sir.
Jono lives with you?
Yes, sir.
You live in Beaumont?
Yes, sir.
With your husband?
Yes, sir.
And how many people live in that house?
Me, my husband, my oldest son, and John.
And how long have you been in that home?
Over 5 years.
And the four of you lived there?
Yes, sir.
Was Jono working when all this happened?
Yes, sir.
Where was he working?
He was working for Jefferson nursing home.
Say again?
Jefferson.
What was he doing?
He was working in the kitchen.
And how long did he have that job? You recall?
I think he had just received that one over there. Maybe 6 months. I'm not. Yeah. Because he just got hired out over there.
And he's 18?
Yes.
He lives with you. He's not. Is he a flight risk?
No, sir. He's not.
Are you worried about him taking off or running
No,
off?
sir. I'm not.
And you wouldn't waste your money if you.
No, sir. I wouldn't.
What bondsman did you talk to?
I had talked to a professional with Kenya, and I had talked also Ellery with Lisa.
Which bondsman was this back in September?
I think that was Ellen.
That was Ella. Is that who you're talking to now?
Yes, one on this.
And what have your conversations been like with them?
They just ready for me to get in touch with them, see if they're not gonna be reduced. I just had one text me this morning.
Have you talked to them about what amount you would want that you're trying to get reduced to? What would be reasonable?
At least 100,000. We had talked on that.
Well, it was 150,000 back then.
Yes, sir.
So it's not really realistic that that the court would drop to 100,000 now.
Mm-hmm.
Are you asking the court to reinstate I don't know, reinstate the correct word, but to go back to the $150,000?
Yes, sir. Yes, sir.
Is that something you think you could work with?
Yes, sir.
They probably want you to sign a contract for $15,000?
Yes, sir.
I think 10%
Yeah,
is the one.
yes, sir.
Would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
And what else would you like to tell the judge? about the bond.
I'm not the one. We already prepared to make fun. So,
Have you seen the video in this case?
yes, ma'am.
Okay.
I have talked to my son. Yes, ma'am.
You've actually
You know-
seen it.
Yes, ma'am.
Okay.
The whole video.
Okay. Anything else?
Nothing else.
Questions of this
That was
witness?
actually one of my questions I was going to ask this witness, whether or not she's seen the video, Judge.
Okay.
In addition to that, Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years your son has been arrested for 9 separate offenses?
9?
Yes, ma'am. Evading arrest as a juvenile, UUMV as an adult, possession of a controlled substance, unlawful carry of a firearm, failed to ID, possession of a controlled substance, possession of marijuana, and 2 additional unauthorized carrying of a weapon. Were you aware of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay. Any other questions of this witness?
No, Your Honor.
Thank you, ma'am. You can have a seat.
Thank you, ma'am.
Any other witnesses, Mr. Vasquez?
No, Your Honor.
Mr. Pullman?
Judge, one of the items of evidence that I plan on introducing was the video from the shootout. It sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to.
Let's just quickly play it. I want to, I'm refreshing my memory by taking, well, first of all, I'm gonna take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case, and I guess it was the other
It was the
case that
co-defendant.
we had a bond hearing on.
Yes,
Is
yeah,
that
yeah.
correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, that would have been January 13th of 2026. My notes include that there was a defense motion to reduce the bond. We argued, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at $300,000 on that date for the same bond hearing.
Yes, Judge.
Your motion's denied. I've already heard all the evidence.
If there is something, Judge, I think that it's at least.
This is a huge problem for the defense. The judge already heard this exact bond argument months ago and denied it. In court, repeating the same story without new evidence almost never works. And once a judge remembers the case personally, that's tough to overcome.
Actually carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments. Do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay. Any other questions of this witness?
No, Your Honor.
Thank you, ma'am. You can have a seat.
Thank you, ma'am.
Any other witnesses, Mr. Vasquez?
No, Your Honor.
Mr. Pullman?
Judge, one of the items of evidence that I plan on introducing was the video from the shootout. It sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to.
Let's just quickly play it. I want to, I'm refreshing my memory by taking, well, first of all, I'm gonna take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case, and I guess it was the other
It was the
case that
co-defendant.
we had a bond hearing on. Is that
Yeah.
correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, that would have been January 13th of 2026. My notes include that there's a defense motion to reduce the bond. We argued, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at 300,000 on that date for the same bond hearing.
Yes, Judge.
Your motion's denied. I've already heard all the evidence.
There is something, Judge. I think that it's at least, if you're going to deny it, I think you may want to consider it as far as whether or not the bond is sufficient. As it states, it's just a 5-minute clip of a jail phone call that I've added subtitles to. If I could do that, I'm happy to bring my sponsor witness, but if you'll stipulate to it.
No, I'm going to object to it to relevance.
Bring your witness, please.
Yeah. I'm speaking as Captain Michael Pond.
Good morning, sir.
Morning.
Thank you for your patience this morning. If you'll please raise your right hand, do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir. Go ahead.
Captain Ponder, would you state your full name for the record, please?
My name is Captain Michael Ponder.
And Captain Ponder, very briefly, what do you do? What are your duties at the jail, over at the jail? That's right.
I'm the custodian of records for the Jefferson County Correctional Facility.
And you're familiar as a custodian of record with the recording equipment there at the jail?
This legal argument about subtitles might sound small, but it matters. The defense is basically saying, what if those captions influence the judge's interpretation? But prosecutors countered fast. If the defendant said it himself, the recording becomes powerful evidence. Reminder, jail phones are never private.
Correct.
Yes, sir.
And it's capable of making an accurate recording.
Yes, sir.
Each inmate is issued a unique identifying number, correct?
Yes, sir.
And that's one of the ways to identify who makes certain calls from the jail, correct?
Yes, sir.
Have you had an opportunity to review what I am marking? Judge, you want me to mark this as states 2 or 3? We entered one in the first hearing back in January. I can do it 1. How are you going to do it?
I mean, it's technically a new hearing.
Okay, I'll do 1. Okay.
1's fine.
All right. You recognize this USB drive?
Yes, sir.
How do you recognize it?
Because I listened to it this morning.
And are these your initials in today's date that's on the USB drive?
Yes, sir.
I'm marking it as State Exhibit number 1. You listened to it. Do you have any doubt that it is a fair and accurate copy of a jail phone call or recording of a telephone call made by an inmate, this inmate, from the Jefferson County Jail?
No, sir. No doubt.
All right, Judge, state opposite. State so.
Mr. Vasquez?
Good morning.
Yes, sir.
How long is this video?
This is
the
an audio.
recording,
I'm sorry, the audio.
It's about a 5-minute excerpt from a 14-minute and 20-some-odd second phone call.
Well, so it's been altered.
It's been included, yes.
I object to the alteration now.
Judge, what's on here is the original 14-minute long video as well as the shortened 5-minute video with the subtitles added. So the original's on here.
Okay.
And by the way, I gave it to Mr. Vasquez yesterday, and he's had a chance to preview it.
States 1, with both, will be admitted.
Permission to post, Judge?
Yes.
Judge, can I finish my objection?
Sure.
Object to the alteration, and then there's a transcription. I object to that as hearsay, where you give
The subtitles.
the subtitles of what you think they're saying.
Do you disagree that the subtitles are correct with what you hear?
I don't know, Your Honor. I just object to it being hearsay.
How is it hearsay?
The subtitles are to what it's someone has written in what they transcribed the conversation to be. I object to that as hearsay.
Mr. Coleman?
Judge, if the audio is not hearsay, which is a statement made by a party opponent, then the subtitles are therefore not hearsay. Judge,
Obviously, we'll be able to listen myself.
Listen to the tone of this call. This doesn't sound like someone shocked by the charges anymore. It sounds like someone trying to calculate outcomes, plea offers, and prison time. And judges pay attention to attitude just as much as words.
And Your objection's overruled. It's admitted.
Permission to publish it.
Yes, and that's both the excerpt as well as the entire. And thank you, Captain Ponder.
Yes.
Call may be recorded or monitored.
Now the conversation shifts toward probation and plea bargaining, and that's risky territory. Prosecutors love hearing defendants casually discuss sentencing because it can make them appear more focused on beating the system than taking accountability. Fair or not, perception matters in court. At this point, the jail call may have done more damage than the original bond hearing itself. Instead of helping prove stability or responsibility, it reinforced the state's argument that supervision and monitoring weren't working. That's exactly what judges look for in bond decisions. And there's the final answer, motion denied. But notice the warning attached to it. The judge even hints the bond could be increased later if more issues happen. That means the court is watching this case very closely now. So what do you think? Should Jonah have gotten another chance on bond, or did the judge make the right call?
months I did, boy, this shit look like very good months of phone, but I think this time been flying by. This is when you get in this one, just flying by. Wow. Sure. This shit. Very vicious. So wow, this is I ain't in the mug, but this shit very big. Something. Man, cause nigga been around young, these hard to do it, I stay out the way. But you know, push gonna come to shove or some shit gonna happen. Boom, you know. Get to the like it was my first write up. Like bitch, I've been chilling talking, quiet, doing that stuff, but that there's just write up, got another write up, I got fire write up, other fire write up. But I think they moved to this on shit. It was check out the other time. So I put me on Thursday, so what's going on? Like shit, so first I guess then my first came in, so I was a KO, boom. I think it's coming out big, it goes back. You know, just feel like this right there, I love come back, and I see that still bring something like that. Oh, okay. They can do that different. Like the flood, you see it, you know. So they ain't no thinking about like this, it has to be good, and he, I also, shit, say, give a nigga probation for worse shit like that. This I know. You come out on top with better position probation for what you give it. They just gave my other part, my free-world project, had 3 robberies, gave nigga, ISL for 3 months and 10-year probation. That's like that nigga, that's what I'm talking about. They gave him ISL 3 months, 3 months ISL. He got 10 years probation. After he was already on probation, 10 years. But crazy, him and the dude that got us in a fight with the court the same day.
That's all I have on that, Judge. Stay at no further witnesses.
All right, anything else?
No, Your Honor.
Okay. So at this time, I am going to deny the motion for a bond reduction. And I guess, Mr. Coleman, depending on any future incidents, if the state wishes to file a motion to increase, I would look at that at the appropriate time.
We have contemplated that, Judge.
But Mr. Johnson, a condition still, if you make that $300,000 bond, is that you would be on house arrest. You would be required to wear a GPS monitoring device at all times. Part of the reason that I'm doing this is because it sounds like you were working, your parents have the issues. I've looked at the bond, the affidavit for them to release surety. It's not just the GPS monitoring device. They obviously were having a hard time getting in touch with you for whatever reason. So I think that makes obviously one of the criteria under 17.15 for bail is that obviously you have to follow all of the rules and conditions of bond, which is with your bondsman as well. And so we will reset your case for an announcement, and Mr. Vasquez will visit with Mr. Coleman, get any offers in your case, and we'll either take a plea if you wish to take a plea at the next court date, or if you don't, we'll do a rejection and get your case set for trial. All right, you go back with the bailiff.